Whenever I'm writing or I'm advocating for someone, I try to never use the patient. I try to use their name. So Mr. Smith or Miss Smith, and try to talk a little bit about them. And when I'm in depositions and stuff like that, I don't really follow the rule. I always ask questions, even if it is my client, and I tell them that my job is to make sure that their story has come across. That no matter what, the other side does, no matter how, they're portrayed, that my job is to make sure that their story is coming across. Because a lot of this, they've been really hurt, and the process almost re-traumatizes them.
Welcome to Bayou Justice, Breaking Victims, Protecting Power. I'm your host, Chip Wagar, a medical malpractice attorney dedicated to reforming Louisiana's healthcare laws. On this show, we dive deep into the challenges faced by patients in our state, exploring how current laws often favor institutions over individuals. Each episode will bring you compelling stories from victims, insights from legal experts, and perspectives from lawmakers. Join us as we work to shed light on these issues and push for meaningful change in the Bayou State. Hello, everybody, and welcome to another episode of Bayou Justice. Breaking Victims and Protecting Power, a production of the Patient Rights Advocacy Forum in Louisiana, whose mission is to change the laws here in Louisiana for medical malpractice victims and make them compensate victims fairly and fully for injuries and deaths caused by medical malpractice here in Louisiana. And today I have with me a guest, Katie Sepcich, who is a young, by my standards anyway, young attorney that is handling medical malpractice cases in the New Orleans area, well, anywhere in the state really, but you're based here in New Orleans,
yes.
Is that right? With the Bowling firm, I think.
Yes. And
the Bowling firm, for those of you that don't know it, has been handling medical malpractice cases in Louisiana for decades, I think, is safe to say. So, Katie, as I understand it, you graduated from Loyola Law School?
Yes.
And then you did some clerking for a couple of judges. You clerked for Judge Foray in Jefferson Parish for a time, and then with Judge Frederica Wicker in the Court of Appeal.
Yes.
Is that right? And then you started with the Bowling firm.
Yes.
So, why don't you tell our viewers a little bit about that? Why did you go into medical malpractice? And maybe what was your first impressions, or what surprised you when you got into doing medical malpractice?
Sure. I originally got into medical malpractice first. I think it's a multi-part question, but the first part is that I was a longtime patient. I went to law school during COVID, which was a very interesting time, and I was sick through most of law school. So
oh, wow.
Kind of learned how to advocate for myself while I was learning how to advocate for others. And so kind of created this passion in me, and I got kind of good at it, I'd say, good at going to the doctor and telling them all of the research that I had done for myself, and thought, maybe I could use this for other people. And then
some of us are like frustrated doctors. If we'd been good at math and science, we would have gone into medicine instead of law. Is that true in your case, do you think?
No. Absolutely not. It's not a knack that I thought that I would enjoy. I thoroughly enjoy looking into the medicine. That's when I was clerking, I worked on a bunch of med mal cases, and there's nothing that's more interesting than the medicine to me, and nothing more complicated in terms of the law than med mal. As far as I saw everything from car accidents to I did some criminal work as well, and then during law school I worked a bunch in family law, and so I had a very wide view of what the law in Louisiana and everything that could come through the door. And the med mal stuff is the most complicated, and I like complicated things, and I like to sit down in a room and try to figure it all out. So that's what interests me. But when I was a patient, I was horrible at math, horrible at science. My only good thing that I could do in school was write, and so which is kind of helpful now. with the work that we do is a lot of writing. So, but no, math and science are not my strong suit.
So when you got out of law school and began clerking and so forth, did you see any medical malpractice cases when you were clerking for Judge Foray in Jefferson Parish, or did you work on some maybe appeals of medical malpractice cases when you were clerking for Judge Wicker?
I did some more so with Judge Foray in the district court. Judge Wicker taught me how to write, and she taught me how to read the law. She's got this saying that I use constantly, that I'm confined by the law. That unfortunately I'm confined by the law, and I use that phrase a couple of times a day. But with Judge Foray, we had a trial that was a med mal case, and then we handled a pretty big med mal case that almost went to trial but ended up settling. But we did a ton of work, and he was a judge that kind of he never treated me like a first-year lawyer, which I really appreciated. He had stuff that he was really interested in and good at, and then I had stuff that I was also really interested in. And so in a lot of ways we would divide and conquer, and then we'd come back to a conference room like this and talk about it and kind of figure it out. And for me, the medical stuff and sifting through a lot of that was kind of my niche that I developed, and then it led me to go off after I left there to kind of do that full time.
So what was your first impressions about Louisiana's medical malpractice system as it exists today and how it impacts people in their lives? What was your first, looking back now, what struck you or surprised you about that?
Well, as a clerk, I'm really looking at the law.
When you talk about confined by the law, we're
Yes.
really talking about confinement when it's medical malpractice, aren't we?
Yes, absolutely. And so especially when you're clerking, I'm just looking at a page, black and white, and then I'm looking at a group of statutes. And so I'm trying to sift through it, and it's very, very complicated. That's my first impression just as a clerk, and there was really not a lot of humanity in it, is what I found. It was, I kind of discussed this with some of my colleagues a bunch. In the writing, it would be the patient this, the patient that, or kind of going through these complex medical terminology and not explaining it. And so Google was my best friend. I would have to Google through stuff and kind of look through, but I felt like the humanity was lost in a lot of it.
What do you mean by that, the humanity being lost?
I think one of the privileges of being a medical malpractice lawyer is the people that are on the other end of the phone, the people that I get to represent and their stories. And a lot of, even though it is complicated and I am confined to the law at this moment in time, I still have a job to advocate for them, and that is a privilege and something that David Bowling, our senior partner at the Bowling Law Firm, he always says it's a privilege to represent you, no matter what the client is, no matter what their story. And the way that he mentors and teaches me is that it doesn't matter what the case, whether the case is big or whether the case is small, we have a job to advocate for those people and to know them, to understand their story, and to be able to kind of bring that forth. And so it's something simple, like whenever I'm writing or I'm advocating for someone, I try to never use the patient. I try to use their name. So Mr. Smith or Miss Smith, and try to talk a little bit about them. And when I'm in depositions and stuff like that, I try to, I don't really follow the rule. I always ask questions, even if it is my client, and I tell them that my job is to make sure that their story has come across, that no matter what, the other side does, no matter how, they're portrayed, that my job is to make sure that their story is coming across, because a lot of this, they've been really hurt, and the process almost re-traumatizes them to kind of go through this medical malpractice system. And so a lot of it I see as my job is to walk through that with them and to not traumatize them in the process as much as I can, and to kind of, limit that as much as well. So that's kind of, but when I was a clerk and I'm not involved in the everyday patient, or the everyday client, sometimes the humanity in it got lost.
It's a little dry.
Yeah, it's a little dry. I couldn't, I can get the story, I can kind of get it, but I'm more focused on the law. And so the story behind it and the condition and the damages, the facts of it kind of would get lost a little bit.
Now, a lot of people think of medical malpractice as, someone leaving a sponge in your body after surgery or things of that nature. And you saw, I'm sure, in your time with Judge Foray and others, personal injuries from automobile accidents and other things. But in reality, the injuries that are sustained in medical malpractice are pretty much as catastrophic as any other form of personal injury. Would you agree?
I would agree. Sometimes even, not to compare people's pain, but sometimes it's even more catastrophic than just the car accident case or something of that nature. Because a lot of times it's gone on for a length of time, and so they've been traumatized over this period of time, and then they're stuck in a hospital for a long time where things are still going on. And so I think the advocacy in it, and when you're a patient, you almost have to learn how to be your own lawyer. You have to learn how to be, your own advocate, and you're doing it in real time before you've ever had time to kind of process it and then go back. And so I think,
and oftentimes without a lot of information or knowledge.
Yep, you're on Google and you're trying to figure out, you're grasping at straws and trying to find anything that you can. And so I think, from a damages perspective, there's a lot of trauma and injury that occurs with a medical malpractice case that is just very unquantifiable and kind of goes unseen in a lot of ways.
And do you find what's your experience when you talk with a client, a prospective client, or a brand new client that you're sitting down with for the first time, and you've heard their story, and it involves maybe a death of a spouse or a child, or quadriplegia or brain damage or some horrific catastrophic injury, and you think that they have a case. What do you tell them about the damages they can recover in Louisiana, and what is their reaction?
I tell them that there is a cap, and
how many of them knew that before you told them?
None of them. And I think, a lot of people, when they have this, unspeakable tragedy, that they're not thinking about the money, they're looking for justice. I get that a lot, and I tell them, because of the way that the law is written and because of these caps, justice does not come from this process. And this is something to where you need to brace yourself, that you've experienced this trauma, and this system almost re-traumatizes you in order to get something good. And this something good, that's what this is about, trying to turn something really bad and trying to kind of grab something good out of it. This isn't justice because of this cap and because of all of these systems that are in place and because we're in a system run by imperfect people. So it's a lot of different factors. It's not just one thing, but my initial conversation is to brace yourself and that we are going to be here for a long time. So we need to become friends, and this is my cell phone, and this is how you contact me. You can call me anytime, but we're going to be here for a bit. So
this is something I get a lot when we're having that first conversation with a client, and I tell them about the cap. And like yourself, most of them had no idea. Some of them do. Some of them have heard that, but most of them have not. They don't know about it. And when I tell it to them, and I want to see if you get the same thing a lot, they tell me, well, I don't care. I'm not in it for the money. I just don't want this to happen to someone else.
All the time.
It's really touching, really.
It is. It is really touching. I think that's why it's a privilege to represent these people.
Yes, I agree. So you've sat down with them, and explained the cap and so forth. A lot of people don't realize that, this catastrophic injury that this person or this family, because really it affects more than the victim. It can be spouse, children, parents, best friends, all of that. One of the things that is not widely known is that the person, the doctor, the nurse, the mega hospital chain or the mega nursing home chain, even if they're found liable for medical malpractice, the most they have to pay is $100,000. And when you see the kind of injuries and death that's meted out, what do you think about? Or what did you think about when you first found that out?
Yeah, that's not something that I knew before because when you're clerking, I'm not involved in the settlement process, or I'm not involved in the payout process typically. And so that part of, the Medical Malpractice Act, I wasn't, didn't really have a lot of knowledge on. But coming and now being a plaintiff's attorney, that part to me was a bit shocking, and how the system works with the $100,000 and how they get a credit when there's multiple defendants. And you almost have to be good at math in order to be able to add it all up and make sure that you're doing the right thing in order to not give someone a credit when they shouldn't have a credit, and all of those different things. So the complexity of the $100,000 and then the total $500,000 still confuses me. And I think it's so confusing for clients. It's difficult. I usually have to bring a whiteboard and we have to map it out and that sort of stuff. But I like to give grace to these providers, because we're all imperfect. If I was judged by every mistake that I've ever made, that's not something that I would particularly be fond of. So as far as, should that be higher, it's tough, because, they can have one bad day, but it's really hard when the damages are so big that they are unquantifiable. And I think understanding that the gravity of your mistake and understanding, what that can do, that deserves more than what the law confines us to at this current time.
And you raise a point that I think a lot of people would raise on behalf of doctors and hospitals and nursing homes and so forth, is that, they had to make a judgment call. Mm-hmm. They had to make a judgment call. And, they didn't have the benefit of hindsight like you do or whatever.
Those are all good defense.
Yeah, they raise that and so forth. And I don't think that people understand that if it really is a judgment call, and they really did think about it, and there were pros and cons to each approach, and they picked one, most juries are not going to hold them liable for malpractice, are they?
That's true.
That's not the kind of case one can take and win for the most part.
Yeah, usually I'm not going to take a case that's like that.
Yeah, nor do we. We can't, because it's not fair.
Yeah.
You do have the benefit of hindsight. So when someone gets a judgment against a hospital or nursing home, doctor, or whatever, they've proved something far more than that it was a judgment call and they guessed wrong.
That's very true.
And so the limitations of $100,000, as you say, when you're, yes, you want to, on the one hand, be fair to the medical profession, the hospitals and so forth. On the other hand, not on the backs of some family that's going to be crushed for life because of this, right?
Yeah.
And so, we turn down a lot of cases. I'm sure you do too. Mm-hmm. And a lot of people wonder, why is that? Why is it so hard to find a lawyer who will take my medical malpractice case? Would you like to explain why that is?
That was something that was surprising to me. One of our practice at the Bowling Law Firm is the new person gets to take all the new client calls. And one of the reasons is because it helps us to learn the medicine and kind of get going, and also learn how to talk to these folks. And and still, I'd still take new client calls and all
Me
of
too.
those things. And so I'm surprised every day by the calls that I get of things that, because we have to prove that there's a breach in the standard of care, and then that breach caused damages. And it is the worst part of my day when I tell someone, you know what, I think that this was a breach in the standard of care. I think that what you're telling me, that there's something there, but I don't see the damages. And I think the caps, that kind of the boot on the neck that it puts to us lawyers is that if it's not something that's catastrophic, it's so tough for us to take because of the amount of money and the amount of time that we have to put into it. And it's not fair at all. And I don't think that people understand that. Like, I'm not trying to be a jerk. It's not that I don't believe you. It's not that your case doesn't matter. It's that I also have to think about a business. And this is how the law confines me. And I have to take a case based on what I think I can get for it. And if it's something that doesn't meet the cap, then it's not something that I can, spend all of these years working on.
You want to take some of these cases, because they're terrible. But if the medicine's not there, as we say, if it isn't a real deviation from the standard of care, or if the damages are just not going to likely be there. If I took all those cases, I'd be out of business. I couldn't help anybody because my law firm would fold. We typically spend on a case that we take, if it gets settled sort of midway through, we're still spending $50,000, expert fees, depositions, court filings, the whole panoply of it. If we go to trial, I've spent as much as $120,000. It depends on the case and the expense. The experts are very expensive, and if you rush this case through, if you get through the medical review panel process, if you push it hard and get through there in less than a year, you're doing great. And then you get into the judicial system and you get it to trial with before 2 years, you're doing great. I mean, that's 3 years with a lot of money out there. And then you could lose. There's no rear end collisions in this business, right? I mean, it doesn't matter how good your case is. Some juries just will not give an award against the doctor sitting there in his white coat, right?
It's very true.
So you're taking a risk with every case that you take. And so I think this is a hard thing that we have to come to grips with as lawyers, is that, I'd like to take a lot more cases than I do, but if I did, I'd go out of business.
Yeah. No, that's very, very true. It's something that I wrestle with like all the time. And sometimes, I end up taking a case and I will take it to the panel just to see if we can kind of sift through it and I kind of view my panel submissions as a way of advocacy and a way of, allowing this person to be heard and then kind of seeing what happens. Usually we lose, but
you're not alone there.
But that's
you know
everyone.
The statistics on that,
Yes.
right? Yes, it's like 90% of the time.
Yes, it's not, and that's why I tell people that this is not where justice comes from, because like I said, I could have and there have been, a lot of cases where I've worked on where we've lost the panel, and it's a very clear deviation. Oh yeah. And that happens all the time. And so that's why
I've had multi-million-dollar judgments that we went to trial on, and the panel ruled 3-0 against us all the time. In fact, I don't think any case that I've ever had a multi-million-dollar verdict in, I've never won the panel.
Yep. It's just almost something that you just got to get through, and then you work up the case on your own, and then you go forward. But it's just, I don't know, it's interesting. That's why I tell people that this is not where justice is, because it just depends on the day sometimes with these folks and whether or not they want to rule for you, whether or not they want to rule against you. And that's kind of in everything. And that's even out of the panel stage. And so you never really know. There's no guarantee with this line of work, which makes it tough, and why you have to have these really hard conversations with these people from the very
So, Katie, why do you keep doing it?
I ask myself that question all the time. I think, it depends on who you ask, but at the end of the day, I think that this work is so important. It's one, from an intellect perspective, we can kind of dog the system is messed up, but the people within the system and the lawyers within this field, I find, are some like the most brilliant lawyers. And
you gotta be on our side. You gotta be.
You have to be like so on your game, and so just it's really amazing to be a part of that group and to learn from these people. And so to kind of interact and have these folks as your colleagues, I think it is really something that keeps me going. And then, like I said earlier,
and the medicine is fascinating.
The medicine is fascinating, but also these people, if I didn't do it, then who would? And, like I said, I think having an awareness of the pitfalls of the system and understanding that this is not where justice comes from at this current time, that this is where, this is a means to an end, and understanding that. I mean, there are some days where I remember last year I worked on this panel opinion, and it was a case that was totally a judgment call. But I wrote this piece and I researched the medicine. They prescribed a medicine that was contraindicative to another medicine that the patient was already on. And it was, whether or not it should have been done was questionable, and I will admit that. But at the end, the patient came to me, my client, and was like, "Thank you for seeing this. Thank you for putting this out there. Thank you for just seeing us in a way that no one else did." And
she didn't get any money.
She didn't get any money. The case was dismissed because we couldn't, meet our burden, and we couldn't go forward with it. And it wasn't necessarily that she was grateful, but when she said, "Thank you for seeing me in this way," that's what matters to me.
Keeps you coming back.
Yeah, it's to be able to, help people navigate this system and navigate, this trauma that they've had in their lives.
For me, one of the other sort of side benefits of it, the reason I keep doing it, is the idea that without checks and balances, most systems run amok. And I think you would agree with me. The disciplinary system of the Louisiana State medical examiners is, unless you're on drugs or an alcohol, malpractice does not get your license lifted in this state. It just doesn't happen. So self-policing just doesn't happen. I don't know what your experience is, but I've seen hospitals that have doctors with multiple malpractice lawsuits, multiple deaths. They're still on the staff.
Not credentialed.
Yeah, they are credentialed, and they are allowed to continue year in and year out. Their peers don't want to censure them, don't want to kick them out. And so where's the check? Where's the balance? What are the consequences for medical malpractice in Louisiana? You're looking at it.
Yep,
that's
true.
It's us, really, or nothing, or nothing. And so I feel like one of the things that keeps me coming back, wonder how you feel about this, is the knowledge that in some small way, you are providing a check and balance to this system.
That's something that I appreciate in talking to, a lot of we talk about this all the time, you can do all this work on a case, and then it really depends on your expert witness and what your expert's going to say. And working with doctors who serve as our experts or nurses that serve.
And that's funny you should bring that up, because a lot of people think that, medical malpractice lawyers, we must hate the medical profession, which is not at all.
No.
We couldn't do what we're doing
Yes.
without help from medical doctors.
No, and what they tell me when
is
you ask
what we
them
go by.
Is why are you willing to serve on the dark side for the plaintiff? And they're like, we need checks and balances. I'm here because I saw this case, and I don't want this to happen to someone else. This should not happen. This cannot happen. And
what they call a never event, I think,
yes.
in the profession.
I always like to work with them, and that's something that I consistently get from them, is that their purpose in serving as experts is to have that check and balance system and kind of be the check, which then I guess I'm also the check. So, no, I would agree.
It's a collaborative effort, isn't it?
For sure.
You cannot meet, I don't think a lot of people realize this, but in 99.9% of medical malpractice cases, you don't even get to court unless you have a doctor who's willing to stick his neck out and say, the emperor has no clothes. This is malpractice.
Yes.
And he did it.
And
that's a lot to ask.
And it's both things. It's asking someone to say that there's a deviation, and then the deviation caused this. And a lot of times you can get someone to say that there's a deviation, but you can't get them to the damages part. Or you can say, yeah, they have damages, but I don't think it was because of anyone's fault. It's because this is just...
They were sick when they got here.
when they got here. And usually those are the folks that, have medical malpractice because they're in the hospital all the time and they have super complicated cases. And that's when the medical judgment gets thrown around, and you have to sift through that. But no, we talk about all the time, it's like you get through the panel process, then you file your suit, and within 90 days, summary judgment, expecting you to have an expert.
You mentioned something a few minutes ago, something that bad can happen in 90 days once you get through the panel process and you file your lawsuit in the judicial system of Louisiana. And it starts with that panel opinion, which 90% of the time favors the doctor or the hospital or the nursing home, right?
Yes.
Why don't you tell our listeners what happens if you're not ready for this, and unlike any other kind of case?
So unlike every other case, the Louisiana Supreme Court has held that for a med mal case, 9 times out of 10 you need expert testimony. There's very few instances within this world where you can get by, but
leaving a sponge in after surgery or something
something really horrendous where it's so clear that normal people will understand. But pretty much always, even if there's a sponge left in there, you want an expert. And so that requires you to have someone ready to go. And if you don't, then the other side is going to file a motion for summary judgment. And on top of the Louisiana Medical Malpractice Act and all the caps and hurdles that we get to go through, the Louisiana legislature and the Supreme Court have really they're very hard on these summary judgment rules. They have their own deadlines. They have their own burdens of evidence that you have to meet within the summary judgment
and within
motion.
Certain time periods.
Yes, and if you're a day late, there is no discretion.
No mercy.
You are out. And so if you have an expert, you find an expert within the time period, but you submit your opposition 14 days rather than 15. You don't get to argue. Your opposition is thrown out, and you're really dead in the water.
Your case is dismissed.
Your case is dismissed.
After all that.
After all of that. And there's no grace within the summary judgment protocol.
And the other side can use that panel opinion.
Yes.
Which, as lawyers, we know is hearsay, otherwise would never be admissible.
Yes.
But by statute,
it can come in.
It can come in, and they can use that to support their summary judgment. And if you don't have a doctor willing to do a deposition or an affidavit and say, no, it isn't, you're out, right?
Yep, you're out. Yep,
you're out.
It's really, and even just a report. If you have your doctor do a report, that's
hearsay.
That's hearsay. It has to be an affidavit. It has to be something, it has to be deposition, it has to be sworn testimony. And it's such a higher burden for us plaintiffs than it is for the defendant, because 9 times out of 10 they do have that panel opinion. And if you have a unanimous opinion, then they're just going to throw that out at you any chance that they can. And so you have to be able to combat that with someone.
And not only that, if it's a unanimous panel opinion, which 9 times out of 10 it is, they can file a motion or bond for costs.
Yep.
Tell us what that is. You don't see this in trucking cases or pedestrian knockdown. What's that?
The idea is that they throw out is that you have to pay the defense to try their case. You have to, there's the bond, and then there's the security costs, and so you have to put up a certain amount in order to say, no, actually, I know that I failed the panel. I know that they ruled against me, but I do have a case. So it is worth everyone's time. It's essentially how I explain it to people, that it's the most bizarre thing that I've got to put up money. And I've seen some of them argue not just for the bond, but for the security costs, and they come in, they're saying, $20,000 that I need to put up on the docket for them to be able to defend this case.
So you have to go to basically an insurance company, or you can put your law firm on the hook for it. But if you go to an insurance company and pay the premium and get a bond for $20,000, let's say, the insurance company wants to know, well, if I have to pay that, someone's got to pay us, for that. It's a surety bond. And most of our clients are poor.
Yep.
And they don't have that kind of money.
Nope.
So it's either put your law firm on the hook, or they can get the case dismissed.
Yep. There are so many pitfalls, and this is why you have to be absolutely crazy to do this work, because there's just so many things. And you have to have so many difficult conversations with people. And, there are just so many opportunities for your case to get thrown out that you have to be aware of. That's why the system just re-traumatizes people.
And so lawyers who are willing to do this, I sometimes estimate on our side, representing victims, I'd say between 2 and 3 dozen at most in the whole state of Louisiana are willing to do it.
Yes.
On the defense side, now they get paid by the hour, and we love our brothers and sisters on the defense side. We know them very well.
Yes.
And there's nothing wrong with what they're doing. They're supposed to do it. But I'd say maybe another 3 or 4 dozen. That's it. That's the whole medical malpractice. And so when people say, I'm having a hard time finding a lawyer to take my medical malpractice case, these are the reasons why it's so hard. And that's what the people who put together this law back in 1975, that's exactly what they wanted, isn't it?
Yeah.
So this program, Breaking Victims, Protecting Power, really what the medical malpractice law is for the rich and powerful, the insurance companies, the hospitals, the nursing homes, and the medical profession. It's not for patients.
No.
It's if there's anything in there that favors patients, it's a mistake on their part, right?
That's true.
This statute, if people read it, it goes on for pages and pages down to the last, comma and semicolon, doesn't it?
Yes.
So one of the things that not one of the things, our mission here with the Patient Rights Advocacy Forum, and the reason we're doing this is to educate people, because I want to tell you something. This just came out a couple days ago. We need to do something about this, because if you compare Louisiana's medical malpractice statute against there's only about half the states, I think it's 26 states, have caps, have medical malpractice caps. But nobody has one like us. No state has a limit of $100,000 for the wrongdoer.
Yep.
No, there is not one. There are only a few states that have the Future Medical Trust Fund. There are only 16 states, I think, that require you to go through a medical review panel like this. And when you put it all together, what we call the trifecta of the medical review panels, the caps that date back to 1975 with no cost of living built in, nothing. It would be worth I think 2.7 million today. That
Yep.
if in today's dollars, and the Future Medical Trust Fund. There's only one other state that has that trifecta. That's Indiana, which our statute was modeled on, and they raised their caps to, I think it's now about 2 million. To reflect the cost of living. Anyway, I've got a news article from Utah, of all places. This is March 4th, 2025, when we're taping this. What is today? The 7th. We're taping a few days later. So Utah didn't have a medical malpractice cap. And a representative, Katie Hall from South Ogden, Utah, decided that they needed one. And she put in a bill to limit damages in medical malpractice in Utah to $1 million, which is double what ours is. It caused such an outrage. People poured into the Capitol. They have pictures of people in the gallery packing and testimonies before the committees and so forth of these, how devastating, how outrageous a $1 million cap would be. It was so overwhelming, the turnout, that they withdrew the bill.
It's amazing.
And they're not going to impose a cap in Utah. And I say that because that's what we're trying to do here. We need people. Most people don't think about medical malpractice until it happens to them. And like you said at the beginning, how many of them knew about caps before they talked to you? Almost none.
Almost none, yep.
And when you do find out about it, it's too late, So what we want to do is we want to get the information out there. Amazingly, a lot of people in the legislature, a lot of senators and representatives, they have no idea. No idea there were caps. 1975? Really? Yeah, they don't know. So we've begun giving newsletters to them to let them know how it is. Public action, people turning out, can make a difference, and that's what we wanted. That's what we're trying to do.
No, I think that's amazing. Sometimes I find that, when we're talking about checks and balances, I mean, if all a doctor has to pay is $100,000, is that a check? When it's something that's so catastrophic.
Your homeowner's insurance is probably a lot more than that.
It is a lot more than that. And so, I mean, really, that's what comes down to it. I think people think, oh, you want to raise the cap, you just want, what's wrong with the world is plaintiffs' lawyers.
Greedy trial lawyers, the greedy trial lawyers.
They just want more money, but that's not it. It's, really what's preventing. If we're going to talk about checks and balances, which I hear people talk about the panel process. Okay, sorry. But I hear people talk about the panel process all the time the panel process was designed to be a check and balance, that it was designed to...
On us.
Yeah, to weed through these cases that are just, frivolous and to figure out what really is a case and what isn't. And that's not what the panel process has become. But what about the other checks? If the whole system's designed to be a check and balance system, is it really doing its job? And I don't think that people get that. They just see it as people being greedy, wanting to take more money and wanting to hurt these providers, which is not the case.
I think one of the reasons for that, the greedy trial lawyer approach, is because, well, first of all, I don't know if you have a Learjet parked at the airport to take you to Vegas this weekend. Or
I don't.
Yeah, most of us don't. Okay, that's just not true.
Unfortunately.
Yeah, no, we're not. We don't have a second home in Saint-Tropez or anything like that. And most of us, if you get $1 million verdict in medical malpractice, believe you me, you've earned it, because it's hard. It's really hard from our point. It'd be much easier to do trucking law, I think. But having said that, the reason I think that the greedy trial lawyer defense is used is because they can't demonize our clients. Our clients are pathetic. They're they've had life-altering injuries that are ghastly. I'm thinking right now of a case I have that I just settled for a quadruple amputee. No arms, no legs, because of medical malpractice. Medical malpractice was so blatant, it was stipulated. As a matter of fact, the doctor who did it is in prison right now for tax evasion. Okay, so this guy has no arms and no legs, and the most that doctor and her clinic had to pay was $100,000. Okay, they can't demonize my quadruple amputee, but they can demonize me. They can make me into the greedy trial lawyer. All we are as lawyers is advocates for someone else.
That's true. That's true.
And so I think that's something we need to get across. When you talk about greed, if you want to talk about greed, maybe we should talk about Ochsner, whose CEO, recently retired CEO, was making an annual salary of $9 million a year. That Ochsner is a $4-point-something billion enterprise employing 37,000 physicians. That the top, I think it's dozen or 15 department heads at Ochsner all make between $1 and $3 million a year. So you want to talk about greed? Let's talk about greed. And I could go on, but we're running out of time. Katie, thank you so much for coming by and talking with us today and giving a perspective of a younger lawyer who's getting into the business. And I really appreciate it. And I hope that we'll have you on again sometime and we can talk some more about this system that we're all trying to change.
Yep, thank you for having me. I appreciate it.
You're very welcome.
Thank you for listening to Bayou Justice. I hope today's episode has given you valuable insights into the complexities of medical malpractice in Louisiana. If you'd like to learn more about our mission or get involved in our advocacy efforts, please visit patientrightsla.com. Your support can make a real difference in the lives of patients across our state. Remember, together we can create a fairer, more just healthcare system for all Louisianians. This is Chip Wagar, and I'll see you next time on Bayou Justice.